I hope that what I'm going to say today is going to speak to all of the themes that have already arisen in the other papers. I'm not really going to talk about my book, although the ideas in this presentation are largely derived from the book, albeit wrapped up in a slightly different way. But what Sharon asked me to talk about was common law's gendered legal heritage, and that's really what I'm talking about. So I'm talking about the common law tradition, and I particularly want to talk about concepts of legal reasoning within the common law tradition. And I'm not really making any sort of big claims about the importance of legal reasoning in the wider empirical world, about the centrality of adjudication in progressive struggles, or anything like that. I'm simply saying that in the context of our use of law and legal concepts in order to advance, if you like, progressive goals, it is helpful to understand and really be able to wield legal reasoning in effective ways, and that's really what drives this. So let's start first with two stories, and these are two stories about the common law from the point of view of gender and women's oppression in particular. And the stories, one is of anger and despair, and the other is of hope and possibility. And that expresses my sort of, you talked about Janice face, my sort of ambivalent attitude towards the common law and towards law in general, in fact. And I think it's an ambivalence that many feminists feel. We turn to the law at one and the same time in order to, if you like, advance progressive interests, combat inequality, and at the same time we see that law is deeply implicated in the construction and maintenance of these inegalitarian regimes that we're struggling against. So it's that sort of ambiguity and that dual feeling at one and the same time. We'll start with anger and despair. We're not short of stories here, but and I wanted to, so this is a story of why feminists might be angry and despairing of the common law. And we first of all need to, if you like, historically specify the common law. The common law, notwithstanding a rhetoric of existing since time immemorial, and that's very important to its legitimating rhetoric, is historically, quite a specific kind of way of thinking about law. It's most associated, particularly if we think about theorizing the common law, with the 16th through 18th centuries, and we associate it with the fathers, Coke, Hale and Blackstone, who were the primary theorists. But the ideas behind the common law go back a lot further. They go back at least to the Norman Conquest, and some say to the 7th century code of King Ethelbert of Kent. And that always interested me because I was usually presenting papers about the common law while I was still at Kent, but it doesn't have quite the ring when you're, at Bristol. We discovered the common law at Kent. But anyway, the central dilemma, I think, of common law theory, as these writers saw it at the time, and I think it's still the central dilemma, is how can law be the creation of human beings? And this was very much an acknowledgement that the common law was the creation of human beings. It was a counterpoint to natural law theory, if you like, but that it exists autonomously in isolation from politics, power, and so forth. And why was this very important, this notion of the common law existing autonomously in isolation from politics and power? Well, this was why, really. This is poor old King Charles I getting his head chopped off, and that was the most graphic one I could find, really. I was hoping for something very technicolor, but there wasn't much around. But anyway, the point is that the fathers of the common law were writing in a period of huge turmoil and political challenge, and it was a challenge against, if you like, the divine authority of kings in particular, and a struggle between the king and parliament. And so basically within that context, lawyers were trying to hang on to the notion of a common law which was, if you like, beyond the power and scope of the king or indeed of parliament, and carve out some sense of the common law as having authority and legitimacy. And that's where they get common law is a product of custom and tradition. Common law is a product of time immemorial. It's if you like, the congealed wisdom of our ancestors. the point that really has been made by our learned fathers is it's not them deciding the law. They are simply finding the law through the application of their artificial reason as highly trained lawyers. So, for example, Hale talks about lex non scripta, to distinguish it in particular from lex scripta, the law of Parliament, legislation, pinned its origins in custom and in immemorial usage, and it's its timelessness, therefore, that confers its authority. It's out of time, if you like. And it was very important that it was accessed via artificial legal reason. And this is important because it's the sort of origin to this notion of thinking like a lawyer and having a legal mind, that there's something peculiar about legal training that produces very wise people who can access things that the rest of us can't see with our rather inferior natural reason. And again, that the point that sort of Coke was making here, and apparently had a bit of an argy-bargy with some king, can't remember which one, was that we all have natural reason, but lawyers develop their artificial reason over long periods of training, and therefore, you know, even the king can't access artificial reason unless he's done the training. And that was the basic argument that gave legitimacy. So you're not making your own decisions. The judge isn't making their own decisions. They're using their training to navigate via artificial legal reasoning time immemorial. Hence we get from Blackstone in particular the Declaratory Theory of Law, which we're all familiar with. Judges are living oracles of the law, he says in the commentaries. They do not decide what the law is, they declare what already exists. And also an important feature of the common law, which is not always highlighted, is that it was a kind of seen as a sort of radical thing in many ways in the context of legal thinking at the time, because common law was argued derives from the accumulated social and political custom. It's a product of community living. It is not existentially out there in the way that, for example, natural law was regarded. So they were not saying that these principles of common law were extracted from God or the universe. They were extracted from the past and a product of community living and derived their authority over time. So that was classical common law theory. Now, obviously, in modern day, our understandings of classical common law theory are much more, if you like, skeptical. Our belief is suspended in the notion of judges as living oracles. But nevertheless, that view of what the common law is and from where it derives its authority and what the role of the judge ought to be still very much informs how we go about approaching the business of legal reasoning. So at the same time as we're developing these classical common law ideas of the classical ideas of common law theory, the common law is in the business of building an extraordinarily patriarchal, highly gendered legal order. This is not, you know, gender subliminally. This is gender upfront and personal. And we could elicit any number of examples of this, and I've just gone through a fair few. The Doctrine of Coverture, of course, which Blackstone spends a lot of time around, is the most obvious one. When a woman married, her personhood became absorbed in that of her husband, and thereafter she suffered what was effectively described as a civil death. She was no longer a person. She could not hold property, she could not form contracts, she couldn't, except in circumstances, even be criminally responsible. So the Doctrine of Coverture is one example. Pity treason, which is one that comes from the Normans. The Normans were a bunch of misogynists. Anglo-Saxon law was much kinder to women before the Normans came. Pity treason basically was gender differential rules for husband versus wife murder. So if a man murdered his wife and was found not to have any good reason, then theoretically he'd just get hanged. If a woman killed her husband, this was an act of treason, little treason, because she was subordinate, she was the subject of her husband. And the punishment right up to, I think, about the 1820s formally was to be burnt alive, although it ceased to happen by the end of the 18th century. But Blackstone attempts to explain that little cherry in terms of preserving women's modesty, that it might be a bit immodest for them to get hanged, far better for them to keep the clothes on and get burnt alive. Rape law, the marital exemption, we have dear Sir Matthew Hale to thank for that. I won't dwell upon it. There were so many weird rules around rape law at that time. Torts governing domestic relations, we all know about them. A husband could sue if his wife was injured for the deprivation of her sexual and domestic services. A wife could not sue, obviously, for the deprivation of her husband's sexual or domestic services, because he didn't provide much in the way of domestic services, but more importantly, because a wife was conceived as the property of her husband, a husband was not conceived as the property of a wife. And even in the 1950s, when a woman in the UK tried to challenge the law of consortium by arguing it should be extended to women, the line the judges took was, well, this is so obviously about women as property, it's illogical to extend it. And therefore we'll just do nothing and leave it to Parliament. Parliament took a fair old time to get rid of it, and they didn't get rid of any of these domestic torts until the 1970s and 80s. So there you go. Denial of rights to children. This is an interesting one. One of the things that's really interesting about this period of evolution of the common law is that it was also coincidental with an intensification of gender discrimination. You actually, gender discrimination understood in the broader sense of not just differentiating between women and men, but also in ways that oppressed women. So, for example, when Locke writes about women in the state of nature, he says that men and women, fathers and mothers, have equal rights and entitlements in relation to their children. He wasn't a lawyer, obviously. But, you know, by the time of poor old Caroline Norton in the 19th century, most of us know about her awful trials trying to access her infant children after a very painful divorce, at a time when women had absolutely no rights whatsoever to their children in the context of marriage. There was also double standard divorce right up until, well, God, I'm not a family lawyer, you know, but the divorce itself was very difficult, even in the 19th century and even after the 1857 Divorce Act. But double standards, women had to behave in order for a woman to divorce a man and a man to divorce a woman, there were very different rules around it. So basically, all of this notion of women and men being different, Blackstone explained in terms of so great a favourite is the female sex of the laws of England. So women were so favoured by the common law that they were caught within this special regime of protection. And there's one more aspect of that, there was a distinction, if you like, between married women and non-married women. A femme sole was an unmarried woman, and she did have most of the same rights as a man. Not all, but most. So it was only at the point of marriage where you truly became subject to your father or subject to your husband. But at the same time, the femme sole was not the same as the, if you like, individual autonomous rights bearer of Blackstone's time completely. And you see here a reflection of two conflicting notions of gender. One is gender as hierarchy, and that comes really from ancient times and biological understandings of women as basically inadequate men, because they lacked the obvious appendage, and ideas of anatomy were fairly limited at this time. They were seen as defective or incomplete men, and therefore their inferiority was because they were sort of seconds, really, on the product line. Whereas as the 18th and 19th century in particular emerge, you're seeing a shift away from gender as hierarchy to, or at least away from what Thomas Lacour calls a one-sex model of gender to a two-sex model, where women are no longer seen as incomplete men, but as completely and utterly different from men. So you get what he calls a biology of incommensurability. And then you see justifications for treating women differently, not because they lack the necessary appendage, but because they're entirely different. So you see And that very much fits with the sort of culture of domesticity and separate spheres in the 19th century. So you can trace notions, broader cultural and scientific notions of sex and gender, and the way in which they play out in the context of legal rules. And you can understand, for example, some of the issues around divorce and the denial of rights over children as to do with these different conceptions of mothers and fathers, very stark differences between the role of the mother and the role of the father. So we have this horrible gender legal order, which we only start to really dismantle at the end of the 19th century with the Married Women's Property Act. And did you know that the doctrine of marital unity wasn't officially declared judicially dead until the 1970s? So, you know, the legacy of that gendered order is still very much with us in the context of a tradition that derives its authority from what? From the past, from custom and usage and time immemorial. So it's a backward-looking approach to the justification of authority, where what we've left behind, or have we left behind, is in fact a thoroughly patriarchal order in which women were subjected and conceived as of property of men. So, just when we feel really upset, we get to the 20th century, and this one really gets me. This is the expression of anger and despair that most upsets me, Miss Gwyneth Bebb. Miss Gwyneth Bebb went to my old Oxford College in St Hugh's, but many years before me. St Hugh's produced some cool feminists. Apart from me, it produced Gwyneth Bebb and also Emily Davies, the lady who accidentally or on purpose fell in front of the horse of the king at the Derby. But in any event, Miss Bebb got a first at Oxford, went on and got a first, I think, in the equivalent of the LPC or whatever, and wanted to become a qualifying lawyer, and applied to join the Law Society, which, as we all know, was a requisite at that time, it probably still is, in order to be a solicitor. And the problem at that time was that the Law Society said, no, you can't do it, you're a woman, and she challenged it, went to the Court of Appeal. Court of Appeal rejected it. This is this big long line of persons cases. We all remember them. We studied them at some point, I hope, in our undergrad, where you see a whole load of cases where women are trying to access the occupations, doctors and so on and so forth, and they're told that they're not persons for purposes of voting, for purposes of occupations and so forth. And what Swinfen Eadie said, "It is sufficient to rest this case upon the inveterate practice of centuries that, ever since attorneys as a profession existed, women have never been admitted to the office, and in my opinion that shows what the law is and what the law has been. We have only to determine what the law is." So you get this reassertion of the declaratory theory, and he goes on then to say, it's not our business to say what the law ought to be, and that's the business of Parliament, blah, 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 blah. So as Saxon Wilson, again in a very famous 1970s book, criticised, called Sexism in the Law, which criticises all these old persons cases, a pioneering work in feminist legal studies, Saxon Wilson, tracked the way in which the common law, again and again, right at the heart of, if you like, feminist combat with common law at the turn of the 19th, 20th century, notwithstanding that we associate with values like freedom and formal equality, it provided the main intellectual justification for the avowed and formal subordination of women. And we must not forget that seeing the common law as this formally equal, depersonalized, degendered conception of law is really very recent indeed. Anyway, the sad thing about poor Miss Gwyneth Bebb is not only did she get denied the right to be a lawyer, but then she went on and got married, had 2 babies, and died in childbirth in the second one in the early 1920s. It's horrible, such a waste of wonderful intelligence and talent. But there you go. Okay, so that's enough of all the anger and despair. Now let's move to hope and possibility, because there's only too many sad stories we can take. I want to look at the common law through that lens of hope and possibility. Can we harness it as a lens for progressive, if you like, interests, and in the context of feminism in particular, given this horrendous past? is there any point in engaging with the patriarchal past of law at all, or engaging with law given its patriarchal past? And again, bear in mind, this is a discursive tradition. That is the nature of, this is the kind of discourse it is. A discursive tradition is a discourse that justifies its, if you like, axioms, not on the basis of logic, but on the basis of, if you like, the past or authority, or this is the way we've always done it. Okay, so it's not our business to say whether Miss Bebb ought to be a lawyer, it's our business to say that she can't be at the moment. So it's that kind of discoursive tradition. And discourses tradition tend to be transmitted through time, so they're transmissions, and that's really important. And that concept of transmission comes from the work of Brian Simpson, who's a very famous common law scholar, particularly in the context of legal history. It's conservative, that should be with a small c, not conservative as in David Cameron, although maybe, but conservative as in the sense of a discourse of traditions trying to preserve and conserve. It's not exactly radical. Backward looking, you're always looking back at how things were decided before. Not rationally based on a logic of authority, as Maitland says, rather than logic itself. And it's slow to evolve. This is the tradition we have. It's slow to evolve. The judges are always talking about incrementalism, okay? They don't like any big changes. And we're always frustrated about that. I think, who was it? It was Anya that was talking about the way in which, you know, when you're engaging with law, you're constantly coming up against what you call law's hard edges, and how do you get round them? And this is partly that, I know that's not in a common law context, but some of the features of the common law are also more generic to law as a way of thinking and organising ideas. And it's that sort of difficulty of navigating these hard edges when you want to engage in change. And of course, law has to change. The common law is touted precisely because, unlike the civil law, it's not a code which is an expression of a particular set of rules at a particular time. It actually is a living law. It evolves, and therefore it captures both the past, the present, and the future in one continuous stream of, dare I say it, reflexive engagement. But anyway, so change is therefore a necessary feature of the common law to make it function, okay? But Martin Krieger, talking about law as a discourse of tradition, argues that actually any kind of discourse of tradition changes inherent in it. He says because the very process of transmission, because a tradition is transmitted from the period in which it's developed to another period and then another and then another, that is impossible to effect without some form of minor incremental change along the way. The very act of transmission generates some degree of change. So what you get then is that a law as a discourse of tradition becomes the repeated reconfiguration of norms. Norms are reconfigured all the time, but in a fairly minor, almost unnoticeable way. A guy called Edward Levi, who was a sort of post-American realist, wrote a really good book on legal reasoning, and he captures that idea of the incremental change by saying that law is a system of rules, but not a system of known rules. And what he means by that is that because what law does is it takes a rule, it applies it to a new set of facts, and in the process of application, you tweak the rule a wee bit, and what you get is a slightly different rule. It looks the same, but it's not quite the same. So what he's saying is that every time you apply the rule using sameness or difference type analogizing or distinguishing argument, you change the rules. So law is a system of rules, but not known rules, either not known in advance, you're making them up literally as you go along, but within this particular context. And so that creates possibilities. There is an element of change in law. There is a sense in which it is always moving on. It's not staying the same. And that's what you want to harness in the context of progressive legal engagement. So Let's then move on to a little bit of legal jurisprudence. I occasionally venture in there and venture out again very quickly. First of all, Neil McCormick, who is described himself as the sort of providing the legal reasoning side of Hart's concept of law. So Hart's concept of law was criticised by a lot of people as not paying enough attention to adjudicative processes, being too focused on rules rather than what judges did with rules, if you like, Dworkin being an obvious example of that. McCormick tried to produce an account of legal reasoning which chimed with and cohered with Hart's account of law. So he started with, and the reason why I'm going to describe McCormick too is because I think he actually really does lay out in a very helpful way the kind of architecture of legal reasoning. Now, lots of people have tried to do this. Duncan Kennedy, a lot of the critics. But I find this personally one of the most clear and intuitively correct or accurate accounts of what we're doing when we're engaging with law, which is why I tend to use it. So he started off, of course, wanting to be true to Hart by saying rules. Rules are at the heart of legal reasoning. And what's at the heart of rules, he said, is the syllogism. Okay, so rules operate syllogistically, so they're logical. So the heart of law is logic, which is what he was trying to say. Now, for those of you who are not familiar with logic, you probably, though, have sometimes heard if P, then Q, P there for Q, and everybody, puts their head down and hopes it. But basically, an example would be all men are mortal. Socrates is a man. Socrates is mortal. So it's a way in which you start with a general proposition, apply it to a particular context, and come out with a logically correct legal answer. So to give you an example, in law, if an employee commits a tort in the course of employment, then the employer is liable. So that's if P, then Q. P, an employee does commit a tort in the course of employment, therefore Q, the employer is liable. So he says legal rules operate syllogistically, they're logical, they're at the heart of law, so law is logical, and so on and so forth. So that was a good story from his point of view. Yay Hart, yay McCormick. But he said, yes, but have to admit there are a few hard cases, more even than maybe Herbert himself acknowledged, where the syllogism, the legal rule, doesn't resolve the problem. And he gave some examples. Well, first of all, the rule may be ambiguous and require interpretation. What is the course of employment? Okay, so that you could do a whole book on that. Okay, the facts may present difficulties of relevance and classification. What do we take into account and what do we not? Because that's really, really important to how you decide the outcome. There may be two rules completely in conflict with one another. How do you decide which one? That's really difficult because rules are binary in application. The rule either applies or it doesn't. So if you have them clashing, you've got no way of resolving it. Or there's no rule at all. The no rule at all situation where you have to make one up. And it's funny because the first 3 chapters of this book, and I think there are 10 altogether, are about the syllogism. And then the rest of the book is about the little exceptions, i.e. the other 7 chapters. So he talks about how you resolve legal problems where the rule runs out or any of these limits arise. And he says what you need, and this is where he really gets me, is you need a good argument. Yeah, but it has to be a good legal argument. It can't be any old argument. It has to be an argument that's acceptable within the legal community and within the contours of legal discourse. So arguments then are at the heart. So you have 2 things pitted against each other. Rules which are binary in application, they either apply or they don't. Or arguments which are scalar in their application. Okay, so you can have 2 arguments and one has more weight than the other, or the judge gives it more weight than the argument you want, and so it tips, it trumps. So arguments are scalar, much more flexible. And where do you get arguments from, McCormick said? You get arguments from values and principles that are inherent in law, but they're only inherent in law because we put them there. They emerge over time in legal practice take, for example, the principle no liability without fault. Where'd that come from? But it's a principle, it's not a rule, it's a principle, and we wheel it out every now and again in tort law. They acquire legitimacy through institutional acceptance of their legal relevancy. Say, freedom, liberty. How many times do judges talk about autonomy, freedom, and liberty as a reason, an argument for finding one way or the other? They arise within the context of the functioning needs of laws as systems concerned with the regulation of human conduct. So these values and principles are, they're subjective in the sense that they represent, if you like, particular viewpoints, worldviews. They are normative, okay? But because they emerge through legal discourse and acquire legitimacy over time, okay, by the time you get to no liability without fault, it doesn't feel like it feels like an objective kind of principle, when in fact, it's a particular stance that you're taking, which is perfectly arguable against. The primacy of consent, the welfare of the child, I could go on. These are all principles that we accord huge weight because the legal tradition does, okay? But that's good. We think, well then, let's just get our values and our principles into the law, yeah? Let's do that pretty fast, okay? And why haven't judges been doing it more? Well, actually, they've done a pretty good job, because look what they did with the common law on women for about 400 years. But putting that to one side, there are constraints. You can't just pluck any old value and say this is going to be a legal value from now on, although Lord Denning did a pretty good job, actually. He did have to work over a period of time by dissenting, until somebody finally agreed with him, and then he said, look at all this authority that supports me, all of his own dissenting judgments. Anyway, but there are constraints in the way in which you can develop values and principles as weighted or weighty arguments in law. And these constraints are what I call McCormick's 3 C's, okay? Consistency, coherence, and consequences. Okay, in order for these values and principles to operate, to deliver law as a functioning kind of system of rules for resolving disputes and maintaining social order, then he argues these values and principles, these arguments, have to operate within the constraints. That is, that they have to ensure there's consistency, treated alike, the principle of formal justice. So if a rule was applied before and the same situation arises, then it should be applied again. So consistency, then there's a need to keep law in good order, which is a slightly different concept from coherence. It's about the big picture, the fit. So it's not just, if we decide it this way, is it consistent with what's gone before, but also does it cohere, fit with the broader picture of law. Dworkin gets into coherence in a big way when he talks about Hercules and his web of principles and all that stuff in Law's Integrity. That's the way he talks about it. So it's about intelligibility and fit. So you can't just sort of thrust a new value in there if it doesn't fit with everything else and talk to it nicely. And then consequences. Consequences lurk in law, and in common law in particular, all the time, and we do not call the judges out on it enough. They're always saying, if we decide it this way, these horrible consequences will follow. Well, will those horrible consequences follow? Who knows? Basically, every time you start to engage in consequentialist reasoning, if you like, the strength of the power of your consequentialist reasoning depends on what you know, essentially. But you then start to embed value choices in law, like the slippery slope. If we recognize liability here, then the floodgates of litigation will open, okay? And then that over time becomes a consequential argument. No, everybody recognizes that, slippery slope, can't go there, and so on and so forth. Nobody stops and says, well, hang on, will it? And even if it does, is that a bad thing? Yeah? Okay. So within the context of law, you've got the rule, which, if you like, provides the formal structure. The syllogistic application of rules provides a formal structure for the argumentative process you're engaged in. But other than that, it's not anything like as important as it should be. Everything depends on the values and principles and the arguments that they support within the broader context of coherence, consistency, and consequences. So that what you get is a portrayal of law as a site of normative contestation. Rather than as a neat system of rules, it's a site where there's just this constant contestation going on that is so low key and it's so incremental over time that we don't even notice it. And that's the part that we need to harness. The bit I really like is where he talks about terra incognita. He says at a certain point a value might be emerging. You know, Lord Denning was the master of the terra incognita, or a principle, promissory estoppel and that stuff. An intermediate terra incognita of principles struggling for recognition. Right, well, unfortunately I didn't read McCormick in detail till quite late in life, so I haven't got time to start, you know, normatively contesting in the terra incognita. But some of you are in an earlier stage in your careers and you might be able to do it. But this is just idea that there's a space there within the contours of the common law and legal reasoning to start slugging it out in a low-key way about values and principles, so long as you do it within the constraints applied. So, how important are these constraints? Well, if they're not that constraining, good, all the better, because we can get in there. Okay, consistency, okay? The idea that like cases be treated alike. Well, this is always held up as an argument, and it's very often used in conservative ways, but actually consistency, or like cases treated alike, to the good lawyer is no problem whatsoever. Okay, because we all know how easy it is to analogize when you want it to go one way and distinguish it when you want to go another way. The way in which I illustrate it to my students is by apples and oranges. I'm sure most of you have heard this before, but here's an apple, here's an orange. Are these the same or are they different? And the students go, ooh. They're the same, they're different. And then one of them gets it. It depends, she says. Well, what does it depend on? Well, if it's shape, they're the same. If it's taste, they're different. If it's, you know, the fact that they're fruit, they're the same. If it's colour, they're different. So I say, exactly. So what does it depend on? And the answer is it depends on the measure of sameness and difference applied. Okay, so when you're basically working with rules, okay, and applying them to new situations, whether or not you apply the rule depends on the declaration of sameness. Whether or not you put the rule to one side depends on the declaration for difference, where you as the arguer, and especially if you're the judge, are in a unique situation of declaring what the measure of sameness and difference is. So I think consistency isn't that big a deal in terms of a constraint. It doesn't mean you're totally unconstrained. There are the limits imposed by text. You have to work with what you've got, obviously. And then there are the conventions and hierarchies that govern the discursive field. And one of the beautiful things about the Feminist Judgments Project is it shows how you can work within those conventions and hierarchies. And still, if you like, you can be true to, if you like, the tenets of law and legal reasoning and still reach perfectly justifiable, totally alternative outcomes. So Levy's example is another way of expressing that. But that's the sort of upside. The downside of consistency is the way in which it enshrines into the law and aesthetics of sameness and difference. So that interiority and exteriority. And that has been very problematic for gender because the past is always your reference point. Is this the same as the past or different from the past? Women gender issues are often placed in a position of having to make special pleading say we want to be included, our situation is the same, and if difference is identified, then they're exteriorized again. So that can work against women, that aesthetics of sameness and difference. Also, it generates in law a suspicion of difference. It's entrenched in the legal discursive landscape, and it affirms a prior norm from which sameness is derived. So again, it's that sort of conservative thing. So consistency does place limits on your ability to work the legal materials. But the more you understand it, the more you can get around it. Coherence, this is a biggie. This is the one that's a big problem, I think. The big picture, making sure that everything fits. And that's really about the concepts and categories, the doctrinal framework within which you're operating. If it's tort law, the distinction between physical injury and psychological injury is a sort of core distinction. And you can see there's a lot of gendered work going on there. But how do you get round that? How do you dissolve that core distinction, which doesn't appear gendered, but nevertheless, if you like, has a lot of congealed assumptions in it? So Oliver Wendell Holmes says that the substance of law at any given time pretty much nearly corresponds, so far as it goes, with what is then understood to be convenient. So he says, law can be quite pragmatic and respond to the times. But its form and its machinery, he said, depend very much on the past. And you're stuck with that form and machinery, okay? And that places constraints, the hard edges, as Anya talks about. Martin Krieger again, whose wonderful essay on law's tradition I recommend that you read. Some kinds of changes, he argues, are more difficult to effect than others. So you might be able to get some kind of doctrinal change, as long as the doctrinal change is one that doesn't upset the core doctrinal architecture. I think somebody over here was talking about exceptions to rules. So don't knock the rule, just create a new exception is a lot easier to do. So he says that the intellectual structures, the underlying conventions, the canons of authority and the standards that underpin a discursive tradition change glacially. Yeah, glacially, ice age change. Okay, so we have to be good at navigating these structures while chipping away at them simultaneously, because they are a big problem. That is why when the Fiend says there's a problem of sex built into the very form of law, that's what she means, at least that's what I say she means. She's not saying that law is inherently or absolutely or universally sexist in some timeless way. What she's saying is that because, if you like, the past of law is a deeply patriarchal past, and that past is still deeply embedded in the structures and forms and concepts of law, if not in the doctrinal rules themselves, that sex and sexism cannot be eradicated, or at least only if you're prepared to, wait to the next ice age. Consequences, this one gets me as well. Okay, so when judges are deciding whether or not to apply a rule or not apply a rule, to apply an argument or not apply an argument, they sometimes argue from consequences, as you know. And this, I think, is where judicial diversity could really make a difference, because arguments from consequences tend to reflect the knowledge of the person making the decision. Considerations of consequences are basically, in order to evaluate the consequences of deciding one way or another, you have to know what those consequences are going to be. The problem is what you know and what you value are very closely connected. Okay? So, for example, if I read a case about, the police not handling a domestic violence call properly, like the Michael case, and the domestic violence victim dying, and then the question of whether there's a duty of care arises. Well, the attitude of most of the judges is, we can't do this. It'll make it very difficult for the police. If we impose liability here, we'll prevent them, robustly investigating the crime, blah, 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 blah. So they're all worried about the consequences for the police. And I'm thinking, but wait a minute, so many women per year are killed by their partners. We have so many stories of domestic violence. The statistics are horrible. 25% of all violent crime costs us $17 billion a year. Hello, if we could just get the police to do this properly, wouldn't there be good consequences? And then I think, but they don't know that. Of course they don't know that. They haven't read Safety and Justice or Sylvia Walby's analysis of the financial costs of the state of domestic violence, because they don't care, but I do. Yeah? So, if you're going to be in a position to reason well from consequences as a judge, then you have to know about stuff, and what you know and what you value are the same. To sort of put it in some perspective, and this is those are both long quotes, and I won't read them out, but I'll explain the context and you can read them yourself. But basically, this is Lord Hope and Smith versus Sussex Police in 2008, where a poor man has been horribly beaten with a claw hammer by his ex-partner, and the police have been just truly dreadful in their, this man appealed for help with his ex-partner, who was, really threatening him and sending horrible emails and texts and so forth. Anyway, he sues, arguing that the police owe a duty of care to him, which they have breached by failing to protect him and to investigate the crime properly. And this is a sort of the tort claim. And they say no, they agree that the police have done a really crap job here, but they say police work elsewhere may be impeded if the police were required to treat every report from a member of the public that she has been threatened with violence to give rise to duty of care, to take reasonable steps, blah, 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 blah. And up above here is all this stuff about domestic violence and how the police have to be a bit sceptical about it because, he says, she says, blah, and so on. Anyway, really not very nice stuff by a judge who doesn't really know what is going on in the policing world of domestic violence. Okay? Then you get a similar case a few years later, based on a horrible story of a young Cardiff mum, Joanne and Michael, and she is murdered by her ex-partner. Police don't respond to a 999 call. Again, a claim is made that goes all the way to the Supreme Court. We're all getting really excited. Are they finally going to do something about this awful situation? And, I know that you judges are usually diligent, okay, but Lord Towson, who did the majority judgment I wouldn't have given him a 2-2. Needless to say, he threw out the duty of care case. He pulled away from the consequentialist argument because people are starting to say, hello, this is not evidence-led, and went on about voluntary assumptions of responsibility. So he retreated to principle because he felt that was a lot safer. But good old Lady Hale and good old Lord Kerr, my mate from back home, they dissented, and they argued that there should be a duty of care. And again, what I love is what Lady Hale says. It is difficult indeed to see how recognising the possibility of claims against police could make the task of policing any more difficult than it already is. It might conceivably lead to some much needed improvements in the response to threats. So she's saying the consequences might be better if we impose liability. She then reveals that she's read this, which came out contemporaneously, and which showed that notwithstanding endless policy exhortations, that the practice on the ground of policing domestic violence was double crap. Okay, all right. I mean, yes, it did. There's no compromise. It was basically the policies are there, but they're not being implemented in practice. And she said, I very much regret to say that some of the attitudes, I love this, which have led to the inadequacies revealed in that report, may also have crept into the policy considerations discussed in Smith. So she gets stuck into Lord Carswell and Lord Hope. If the imposition of liability and negligence can help to counter such attitudes, so much the better. And the other person who stuck up actually dissented in Smith and then wrote a lovely article and then sadly died was Lord Bingham. But again, he took the line that, well, actually the consequences of imposing liability here might be very good. Yeah. So again, arguments for consequences depend on what you know, and because the judges don't know anything about domestic violence, yeah. But if they did, like Lady Hale, then better decision making might occur. And that's why I say anger and despair versus hope and possibility, because you see both here, anger and despair, hope and possibility, both simultaneously expressed in a few cases. And that's all I have to say.